Welcome to Advocating with Empathy, Awareness, and Practical Guidance for Working with Unaccompanied Minors with Disability. Yes, we're aware the title is pretty long. My name is Marissa Barrera. I'm the Managing Social Worker here at CILA. I'm a Latina woman with dark wavy hair. I have a round face and black eyes. I'm wearing a black top, and my background is a white with a blue American Bar Association logo and a purple circle CILA logo behind me. I'm joined by my wonderful colleagues, Laura Egan, Managing Attorney for Pro Bono and Communications, and our wonderful social work fellow, Shalom Hernandez. Thank you so much for joining us today. I know some of you are familiar with CILA, but for those who are not, let me tell you a little bit about CILA and the services that we provide. CILA is a project of the American Bar Association Commission on Immigration. We're a legal resource center and a capacity building organization, meaning that we do not provide direct services to the youth. Our services and support is to all of you, the advocates. We also believe that no one should go to court alone, let alone children, and that's one of the primary reasons we're doing this work. We are based in Houston, Texas, aka Paradise. However, we have staff in San Antonio, Austin, Dallas, and California. We offer 5 national working groups and 1 Texas-specific work group. This is to provide space for all of you to collaborate and support each other through your advocacy work. We create and provide workshops, trainings, and webinars such as this one, and written resources. We also host a platform featuring pro bono opportunities across the country and provide resources related to pro bono work. We also provide legal and social services technical assistance. So if we could ever be a support to you, please do not hesitate to reach out to us to support you and your work. We also want to take the time to thank you for the work that you do, for choosing to be advocates for immigrant children, and for doing it with courage, competence, compassion, and creativity. We know that this is not easy work, and yet here you are. So thank you so much. Just a few things before we get started with the presentation. This is going to be an hour and a half long webinar. For your questions, please submit them in the Q&A box rather than the chat box. This is going to help us keep track of your questions. We're going to try our very best to answer all questions as we go along. But if we do not get to your question, we encourage you to follow up with CILA by submitting a technical assistance request. The materials for this webinar, including this PowerPoint and a handout and resources, have been uploaded to our webpage created for this webinar. That link was emailed earlier this morning via your Zoom registration. It was also probably dropped on your chat box right now. I'll be emailing it as well later after the webinar. The ABA is going to be seeking CILA credit for this webinar. You must attend today's training in full to receive credit, as partial credit will not be provided. Please note that during the training, I'm going to be announcing a CILA code. After the training, we're going to be emailing all attendees a CILA attendance confirmation form so that those who would like CILA credit can request it. You'll be asked to verify your attendance of today's training and to provide the CILA code that I'll be announcing. So be listening out for that. We're going to be providing also a feedback survey that is going to open automatically right after the webinar ends. Please take a brief moment to let us know your thoughts of today's training, as well as your ideas for future topics to cover. These are the talking points we hope to touch on today. Maybe some of you had the opportunity of attending the Acacia webinar a couple months ago. I attended, and I know that they provided valuable insights into navigating complex legal and court systems for unaccompanied immigrant children with disabilities. They also highlighted the intersection between access to justice gaps and how these gaps are exacerbated for this population. We are so thankful for Acacia for providing the space and time for this conversation to occur. And today we're happy to be able to continue that conversation with all of you. We understand that whether you serve as an attorney, legal staff, or social service staff, working with this youth present many challenges. Medical and emotional concerns, lack or limited resources and support, including navigating stigma and cultural nuances. Recognizing and addressing these challenges is essential for providing effective advocacy. Now, we recognize that this is a huge topic and we won't be able to address every challenge today. However, many of the tips and guidance that we're going to be sharing with all of you can be applied across many situations and challenges. I've been a practicing social worker and a therapist for my whole professional career. I have empathized, supported, and advocated for many children, teens, and families. Alongside them, we have navigated many complex challenges, including trauma, mental health concerns, and disabilities. We do not consider ourselves experts on this topic. Probably among the three of us, we have likely navigated many of the challenges you're currently navigating with your clients. We know that through our successes and failures navigating these challenges, we have learned valuable lessons that we humbly aim to share with you today. Our goal is to offer guidance that can assist you and your clients navigating challenges more effectively, possibly helping to avoid and minimize such difficulties. During registration, we were asked if we were going to be covering specific topics such as matter of MAM or immigration relief. While we believe this, of course, are indeed very important topics, we won't be exploring those topics today. However, we have put together a handout with valuable resources for those who wish to explore those particular areas further. We wanted for this webinar to focus on providing practical guidance for navigating medical, emotional, and social challenges with clients, while also fostering autonomy and self-advocacy and encouraging community building. If you know CILA, we love to incorporate an icebreaker through Slido. This sometimes help us to break the ice, but sometimes these questions help us gain information of what challenges you're currently facing, and this help us maybe tailor future resources and training. So I want to encourage all of you to scan the QR code on your slide or go to slido.com and insert the number on the slides so we could launch our first question and we could hear from all of you. I'll give everyone a moment to do so. Our question for today: what challenges have you faced while working with clients with disabilities? Burnout, informed consent, communication. I don't plan to read all of them because I'm pretty sure they're going to start coming in pretty quickly, but we keep track of your information and it helps us tailor future reading resources or trainings. Thank you for sharing. I see communication is a big one. Resources, consent. Yes. Happy to say that we're going to be covering quite a bit of the challenges that you're posting here today. Thank you for sharing. Yes. A lot for communication resources. Thank you so much. Yes, this is coming fast. I cannot keep track, but believe me, we do follow up and we do read them, and I'm pretty sure all the participants are also empathizing, right? We have all navigated many of these challenges, and we hope that we could provide some tips and guidance. Thank you so much. We're going to go ahead and get moving as this presentation is pretty packed. Thank you so much for sharing. So without further ado, let's dive into today's conversation and explore how we can advocate with empathy for unaccompanied minors with disabilities. Recognizing and acknowledging the challenges faced by your client is essential for many reasons. Firstly, it validates their experiences and struggles. It affirms the importance of advocating for their rights and well-being. It also allows us to identify areas where support and intervention are needed most urgently. And all those things provide us with a foundation for tailoring more effective advocacy, one that addresses the specific barriers, obstacles they encounter. Also, bigger picture here, awareness has been known to empower and encourage advocacy that can lead to the dismantling of systematic barriers and for the policy changes that promote inclusivity, accessibility, and equity for all individuals, regardless of their immigration status or disability. And now I'll hand out the spotlight to CILA Social Work Fellow, Shalom.
Hello, thank you, Marissa. Hello, everyone. Yes, I'm Shalom Hernandez, Social Work Fellow at CILA in my last semester of my Master's of Science in Social Work program at UT Austin. I have lived experience with a disability as I have a physical disability. I use my walker, which I've named Azul, to ambulate, and I'm a wheelchair user. I consider my mobility aids an extension of myself. I'm a Hispanic woman with dark black hair and brown eyes, and I'm wearing a black dress, and I use she, her, ella pronouns. Thank you. Next slide, please. So what are we talking about when we use the term disability? The term disability is defined in different ways depending on the institutional, cultural, and legal context. We'll define and explain disability, and further into the presentation, we will cover preferred language. So the American with Disabilities Act is a federal law that protects the civil rights of people with disabilities. The ADA defines an individual with a disability as a person who has a physical or mental impairment that substantially limits one or more major life activities. A person who has a history or record of such impairment, or a person who is perceived by others as having such an impairment. Major life activities are the kinds of activities that you do every day. For example, like eating, sleeping, speaking, breathing. And physical functions are activities such as walking, lifting, standing, bending. Cognitive functions such as thinking and concentrating, or your ability to perform tasks such as working, reading, learning, and communication. As well as includes operation of major bodily function, which includes your individual organs. So disability encompasses a wide range of experiences and impacts individuals in many different ways. So to further understand disability, let's touch upon disability models. The two main models of disability are the medical and social model. These models guide the understanding of disability experience from different perspectives. So the medical model of disability views disability as an impairment, a defect within the individual. It views disability as something that needs to be fixed or cured. This model is important because individuals receive medical diagnosis, which helps people with disabilities to be able to access services, and helps provide the documentation of disability, which some unaccompanied youth will need, helping to support the need for accommodations in an official capacity. The social model of disability centers on an environment or society not designed for people with disabilities, not the individual. It does not deny the reality of disability, but highlights that due to societal barriers like physical, attitudinal policies, communication, and stigma, life with a disability can be more difficult to navigate. It emphasizes how if society designs its physical and social infrastructure with people with disabilities in mind, then people with disabilities will have full ability to participate in society. So let's go into types of disabilities. Four main categories of disabilities are physical, developmental, sensory, and behavioral emotional. The categorization of different disability types is not exclusive, and this is just an example. Some disabilities may be categorized in multiple categories or be identified in a different group, depending on the perspective the disability is being considered from. So for example, for physical disabilities, this can include orthopedic conditions, conditions such as cerebral palsy. It affects your mobility in your legs, hands, arms, or other parts of your body. It can also include vision loss and hearing loss. Developmental disabilities are learning disabilities, such as dyslexia, dyscalculia. It also includes attention or ADHD, or attention deficit hyperactivity disorder. Sensory disabilities such as autism, sensory processing disorder, can also include vision loss and hearing loss. And behavior or emotional disabilities. This includes your psychiatric disabilities. It can include depression, anxiety disorders, post-traumatic stress disorder, to a level like that significantly impacts your activities of daily living. So with that, disability experience. Disabilities can be acute or chronic, congenital, meaning by birth, or acquired later in life through a condition or a car accident, for example. One can experience coexisting conditions. This is when more than one disability or condition is present. Disability can be visible, meaning you can see the need for mobility aids or support, such as in your physical disabilities. or invisible, which includes more of your psychiatric disabilities and your learning disabilities. A disability can affect one's thinking, talking, or moving. It can change a person's ability to socialize and work. It can affect for a short or long period of time. Some physical disabilities, sensory and behavioral emotional disabilities can be acute or chronic, and it is important to discuss the necessary accommodations with your client to ensure that these are provided. We recommend you keep in mind also like the changes in fluidity in both physical and mental or psychiatric disabilities. So recognizing the strengths and challenges. It is important to recognize individual strengths and challenges as disability is personal. Engaging clients in detailed discussions about what their typical day looks like will help gather essential information about their functional abilities and limitations. So practicing active listening to show that you're paying attention, such as nods, facial gestures, body language, and reflective listening, such as rephrasing or restating what the client said to you for them to know that you are understanding what they're communicating in connection to their disability. Such as the example here, like, I hear you, I hear how difficult the situation has been for you, and it's understandable for you to feel overwhelmed. Exploring how symptoms of disability affect daily activities like school, work, and sleep patterns is essential for understanding their impact on overall functioning. So clients who feel heard and understood will be more comfortable requesting accommodations. For accommodations, ask the client what accommodations they might need. How can you best support them within your capacity? Listing the types of accommodations provided under the Americans with Disability Act or the accommodations your agency provides might be useful for clients who are unfamiliar with accommodations. This can range from physical accommodations that we discussed, the types of disabilities like making sure buildings are accessible, to providing sign language interpretation, to providing large print, assistive listening devices, closed captioning, and as you can see, the other accommodations illustrated on this slide. Accommodations can also include like giving the client more time if needed, giving breaks, permitting hand fidgets, or meeting in shorter timeframes. So important to keep in mind transportation accessibility to and from places as well. So collaboration. Collaboration between the client, medical professionals, and service providers, such as legal service providers and social workers, is essential to provide a holistic service. This collaboration gives clients the opportunity to be evaluated and diagnosed with a disability. And as we mentioned, like official diagnosis will help the client access services and receive the assistance and the accommodations they need. And as this example illustrates, an LSP and a social worker collaborate to educate the court personnel about the client's specific communication needs, advocating for the presence of both a certified deaf interpreter and an American Sign Language interpreter during the court proceeding. So that is one way of collaborating. And Laura will be speaking more on the process of collaboration later on in the presentation. So for now, I'll pass it over to Marissa.
Thank you, Shalom. There are many things that shape who we are and what we become. That includes our DNA, environment, but also culture, which plays a very pivotal role in shaping who we are and who we become. It instills values, beliefs, norms, practices that influence our behavior, perception, and interactions. I encourage all of you to acknowledge the intersectionality of these identities and experiences, including race, ethnicity, gender, sexuality, socioeconomic status. This can help all of us recognize that individuals may face multiple forms of discrimination and marginalization, making their challenges even more complex. For example, a young immigrant girl with a disability may face unique barriers and challenges, and that differ from those faced by a young immigrant boy with a disability. Recognize and acknowledge culture nuances as well. For example, in Latino communities, be aware of familiarismo. Familiarismo is a culture value emphasizing strong family bonds and interconnectedness. For example, a Latino youth decisions regarding their care and advocacy may involve the input and influence from extended family members, not just their parents or legal guardians. Cultural humility entails acknowledging and respecting the roles of extended family in decision-making process. This might mean involving and communicating with extended family members, maybe grandma, madrina, aunt, ensuring their voices are heard and their perspectives are considered. Some cultures may also view disability as a source of shame or stigma, leading to reluctance to seek support or services. Cultural humility involves navigating this by engaging in open and non-judgmental conversations about disability, addressing misconceptions, highlighting the strengths and capabilities of individuals with disability. Recognize that the faith and religion might play a big role in your client's life, where prayer, their spirituality is part of their internal tools, their strengths for navigating challenges in their lives. Overall, cultural humility involves ongoing self-reflection from all of us, learning and openness to diverse perspectives and experiences. I want to encourage all of you to advocate always with a humble and culturally curious approach. And now back to Shalom.
Thank you, Marissa. Yes, for disability language, a good approach to disability language, okay, yes, thank you. A good approach to disability language is to address clients always with empathy and sensitivity as a person and ask them what their language preference is. It is important to note that this is from U.S. cultural disability perspective, so some other countries might not apply these language styles when describing people with disabilities or make active efforts for inclusivity. So person-first language. Person-first language of disability emphasizes the person before their disability or condition. For example, Shalom has a physical disability, a person living with depression, a person with a mental disability, a person with autism. That's person-first language. Person-first language is most used in formal writing when describing people with disabilities. Person-first language conveys the person is first before their disability. But there is a cultural shift happening among the young disabled community to describe themselves with identity-first language, as disability is integral to who they are and how they navigate society. So identity-first language emphasizes disability as a core part of one's identity. As I said, the disabled community is taking back the word disabled, a word that had negative connotation and that was meant to decrease the value of a person, and saying we are disabled, and that affects our existence in many different ways. So shifting the lens to dispel the notion that disability is an unfortunate affliction and reinforce disability as a positive cultural identifier. For example, identity-first language is wheelchair user, autistic person, deaf person, blind person, or you can all disabled individual, or you can just say disabled, deaf, blind, autistic. Disability language can be sensitive when working with youth, and cultural considerations are important, as some might not be knowledgeable of this language preferences. You might have to explain person first versus identity first language to your client, then ask for what the preference is. It is recommended to ask and follow through with the language style preferred by that person. For example, in my own personal and lived experience, I am a disabled Hispanic woman. I have a physical disability, as I mentioned. I'm a wheelchair user and utilize my walker to ambulate as well. Personally, I did experience big emotions around my disability growing up, especially in my adolescent stage. I wanted to be seen for more than being disabled. I would say disability is being part of me, but it is not all that I am. During that adolescent stage, I preferred person-first language because I wanted people to know that I was more than just my disability. But fast forward to a decade later in grad school, I've taken disability theory courses and learned through my self-advocacy as to navigate different systems and truly just live that I prefer identity-first language. And I'm very proud to be disabled. I am comfortable associating positive identity-first language with my person. It is very common for me to switch between both identity-first and person-first language interchangeably but do your best to be consistent with the preferred language style that your client prefers. Moving on to more disability language. So words do matter, but we're all learning. It's all continuous learning process. So this is a set of lists with a few examples listing some common used language which for the disability community can be considered more disrespectful, outdated, and ableist, and prefer language that fosters more inclusivity. So ableism is a set of beliefs or practices that devalue and discriminate against people with physical, intellectual, or psychiatric disabilities, and often rests on the assumption that disabled people need to be fixed in one form or the other. And you can find more terminology in the additional resources page on the disability language guides. But for example, some commonly used terms or language is wheelchair bound or wheelchair confined. That is an outdated term, and preferred language will be wheelchair user or person who uses a wheelchair, as this mobility device is a medium of independence. Able-bodied or normal, common terminology to preferred language, non-disabled person or person without a disability. Psycho or deranged, common terminology to person with a mental illness or person with a psychiatric disability, preferred language. Visually impaired, this one, the word impairment can carry a negative connotation. However, it is significant to note it is commonly used in medical settings and for documentation. But blind can be used for people who have complete or almost complete loss of sight, and other terms that are acceptable for those with some vision loss, like low vision, limited vision. This is very to the person as well. Some people do prefer blind, just blind is fine. So it's very important to ask the person what the preference is. Here as well, commonly used language, it's hearing impaired, but people usually prefer deaf or hard of hearing. So most people in the deaf community prefer the use of the lowercase d to refer to audiological status and the use of capital D when referring to the culture and community of deaf people. Some people with mild to moderate hearing loss may affiliate themselves with the deaf community and be referred to as lowercase d instead of hard of hearing. So with these two different types of disabilities, with vision loss or hearing loss, it is very important to really ask the individual, as there's a lot of preferences. And some other commonly used term was mental handicap, but preferred language is a person with a developmental disability or a person with a learning disability. So how you may have to use the outdated language and terminology for medical and legal purposes. Just be conscious of the language you use when communicating with your client, and highly stressed, use their preferred language style. And some general tips for creating a supportive and non-judgmental environment. So be patient and flexible, allow for breaks and adjustment based on individual needs. For example, clients with ADHD or clients with autism may need more breaks, so budget for more or less time if client cannot meet for as long. Individuals who face communication difficulties such as speech disorder or processing disorder may require more time to express themselves fully and effectively, so allow for that time. Certain disabilities may impact processing speed as well, making it necessary, like I said, for extra time for the individual to comprehend the information, formulate responses, or complete tasks. And youth with physical disabilities may require additional time for tasks such as mobility, accessing materials, or transitioning between activities. Proactive listening. So another tip is proactive listening. Demonstrate through body language and rephrasing that we covered of the client's statements that you just are attentively listening to them and to what they have to say. Adjusting environments. This can include changes in lighting, sound, sensory processing, meeting room structure, providing objects or materials such as hand fidgets to the client. So youth with sensory disabilities such as autism may experience sensory overload or fatigue in extended social interaction. So that's why adjusting environments can make the difference. Use preferred language style, as I talked about, person first or identity first language. And ensure accommodation needs are met, following the Americans with Disability Act and other laws that support minors with disabilities. So accommodations such as providing large print, assistive listening devices, sign language interpretation, physical accessibility, and lastly, empower and advocate. Encourage and support unaccompanied youth with disabilities by informing them about their rights and available resources. Empower them to advocate for themselves, to express their needs, and assert their rights confidently, fostering their self-confidence. Thank you for listening. I'll pass it over to Marissa.
Thank you, Shalom. When advocating for client, it is crucial to recognize the unique circumstances that they're facing. Unlike children who travel with their caregivers or parents, or those who are being reunited with parents, unaccompanied youth many times reunite or live with sponsors who may not know them very well or have limited information about their specific needs. Sometimes this is even the case when they're reunited with parents after a prolonged separation. In this situation, it's very important to communicate with that person who knows your client best. Sometimes that person is going to be someone maybe back in their home country, maybe an aunt, abuelita, or a madrina, or somebody that was taking care of that youth. This is essential for understanding the child's background, medical history, or any specific needs related to their disability. You may need to ask detailed questions about the child's medical history and previous treatments or therapies received, any accommodations or support services they may require. If possible, you may want to talk to your client's teachers, social workers, or healthcare professionals that they saw. This can help you learn their educational background, any accommodations previously provided, in areas where additional support may be needed. For unaccompanied children who are detained, it is essential to consider their mental health and emotional well-being as well. Advocates may need to collaborate with clinicians or case managers or mental health professionals to assess and address any trauma, anxiety, or other psychological challenges the child may be experiencing. For example, let's say that you have a client who's currently residing in a shelter. The child has history of trauma. Recognizing that, you can collaborate with a child's clinician, case manager, or mental health professional to tailor your advocacy effort. Together, you can develop a plan to provide the necessary support, intervention to address the child's psychological needs, post-reunification, and also during the legal process. Additionally, establish referrals to organizations such as the Young Center. We highly recommend that, which specializes in advocating for the rights and best interests of unaccompanied immigrant children. Can be very invaluable to providing comprehensive support and guidance. And now to Laura, who will be talking to all of us about supporting clients as legal service providers.
Thank you so much, Marissa. Yes, hello, my name is Laura Egan, and I'm a managing attorney at CILA. And my pronouns are she, her. I'm white, I have long brown hair, blue-green eyes, I wear glasses, and today I'm wearing a blue dress with dingle earrings. I practice law primarily in two areas. I started my career practicing disability law, where I helped individuals seek Social Security disability benefits and supplemental security income benefits. I represented hundreds of clients in administrative law hearings to seek disability benefits. I work with clients with a wide range of backgrounds and medical and mental health conditions, and I practiced in this area for several years. Then I transitioned my career into practicing in immigration law, where I predominantly focused on legal defense work. My prior experience proved helpful when practicing in immigration law as well, so I'm going to be sharing today based off my experience and what I've learned along the way. So now we're going to be covering some information related to supporting clients as legal service providers. So there are many reasons why a disability may be relevant when working as an immigration law legal service provider. There's several forms of legal relief where your client's disability or a witness's disability may be directly relevant to their legal case or affect it in some way. So you may need information related to their health condition for the case to create a legal strategy or to develop supporting evidence. And of course, many claims include discretion as well, so then it's a factor. So I'll give it just a few examples. One example might be that your client has a disability and this forms the basis for a PSG for an asylum claim. So then information will be directly relevant. Another example might be that your client has a difficult time with memory and concentration as a result of their mental health. And this might impact their ability to testify. And you want to document this condition to support any arguments for accommodations and to persuade the judge that this shouldn't negatively impact their credibility assessment. Another example might be that your client has PTSD based on past trauma they experienced. And so this relates to the basis of their asylum claim and the fear that they have to return to their home country. In other situations, sometimes the immigration case may not be related to their health condition. Legally speaking, it's not part of your case strategy or maybe not a big part of your development of evidence, but there may be a significant impact on your working relationship with your client. So it's helpful to know what your client is navigating, what they're going through as they're adjusting to life in the United States, and they may need additional support and they need assistance to get connected to services. Additionally, like I said, this may just create another layer of what you need to do and be aware of as an advocate to try to have an effective working relationship. I also think that this is important to be aware of so you can more holistically and fully advocate for your client. You might need to be more tuned in to safety planning and screening to ensure that they've been treated appropriately in different contexts. That might be at the border, at ORR, by their sponsor, at school, to check in and see how they are, how they've been treated. Unfortunately, injustices do occur, so it's important to be aware of and to be paying attention. If you happen to read some of the annual reports from the Office for Civil Rights and Civil Liberties to Congress regarding the investigations they do and updates, you'll see that several issues do relate to health conditions and medical needs. And unfortunately, there are instances where individuals with disabilities are discriminated against or experience injustices at the border. So knowing this, I think it is helpful to screen clients for what happened to them at apprehension, how were they treated, and it may lead to a CRCL complaint or another complaint for accountability. That is a little bit outside the scope of what we're talking about today, but I thought it was important to flag. And we do have resources on that topic, some of which are in the handout that's been provided. So how is this going to come up? You know, when I was working in disability law, we were hired to represent a client to seek disability benefits. So this was a topic of conversation and the case always. But in immigration law, this came up in different ways. Some clients may come to you and you may easily observe that they are going through something medically. So it's observable and it comes up in conversation just naturally. Many conditions are observable and many are not. So that's important to know. Other times someone may readily share a medical condition that they have, or maybe in the case file, there's a mentioning of something. So you already have a little bit of notice based off of the file that you're reading. And sometimes somebody might have migrated to the United States to get medical treatment. So it might come up directly when talking about their migration story. In other situations, no one will share anything with you. You don't read anything in a record, but you're just talking with someone and they may show some different signs or express symptoms that line up with a particular medical condition. In this situation, you may decide to have a conversation with them about that. You may want to offer to connect them to different services and resources. It might be something that you talk about and explore together. You might encourage someone to seek medical attention or counseling or provide them the option to refer them for an evaluation. This is a delicate conversation to have, and the type of medical treatment or evaluation is going to depend on the situation. And the extent that you get involved may also depend on, you know, if this is directly tied to their case, or is it really impacting your working relationship, or is this something they're really interested in talking about and exploring with you? So there's a lot of factors that play here, and no situation is going to be alike. But it may be instrumental to the client and possibly very significant in their legal claim to explore this. And to have that diagnosis can be really important many times, as Shalom said. I'm going to just have a quick ethics mention here. Briefly for lawyers, in terms of ethics, you know, we're working for our client and listening to their express wishes, their express interests, rather than their best interests. Young Center, and we'll talk more about them later on, can present a child's best interests. Also, generally, when working with a client with a disability, we're trying to maintain a normal client-lawyer relationship as much as reasonably possible. So there are some nuances here, but just at baseline, we're trying to maintain that normal client-lawyer relationship. So I think that's really important just to keep in mind throughout the representation. And obviously, go to your ethical rules for more exploration if you're working on a case like this. This is not an ethics training, but we thought it was worth just flagging here. So learning more about the medical condition, you know, you're going to be learning about the medical condition in a variety of ways. First, certainly learning from your client, you know, trusting them to know themselves, their body, and you'll also likely need to have conversations with others in their lives as well. This is particularly important, I think, in children's cases that you're going to want to learn from adults who know that child well. Their perspective may be very helpful, might provide explanation, context, and just get the information that you really need. You want to do your own research. It's important to be generally familiar with medical conditions so you can spot certain issues. I think in this area, particularly being familiar with certain mental health conditions is important, particularly because many of our clients have experienced past trauma. And we do have a resource and different resources available in the handout to help you with that. But also just as you become aware of something that's going on, research it, learn about it. And this is going to help you read the medical records better. This is going to help you have more informed conversations with your client and others that you're working with in the matter. I do want to just give a general word of caution here. Remember your role. You're not likely in a position to diagnose anyone. Maybe some of you on the call are, but that's not the majority of us. And so just because you know a lot about something, you're not the expert. That's not your role. Don't want anybody to try to diagnose people. That's not the suggestion at all here. We're also going to want to get records. So records from the Office of Refugee Resettlement, ORR. Those may be helpful for youth that have been detained. You want to get medical and mental health records to support the claim, any school records that may be relevant, and then you might want to refer your client for an evaluation. So the type of that provider, the type of that evaluation, it's going to differ depending on what's going on. So for example, if a client experienced past trauma, or which is torture or significant abuse, you'd want to get a physical evaluation that shows any signs or scars of that past experience. If a client has a mental health condition, you likely want to get a psychological evaluation. There's an intellectual disability, likely want to get intelligence and adaptive testing. So it's important to work with your clients and medical professionals to identify if the client has a medical condition and could benefit from any accommodations. Just some practical tips here. I've talked with many clients about their medical history and learning where we need to order records. You're going to want to ask for a list of their medical providers, medical history, counselors, psychologists, hospitalizations, medication lists, just to name a few key points. And my preference always was if a client could bring in a stack of business cards for their providers. And this is just a very easy way to get that list of providers that they're seeing that you want to order records from, and you can just make a photocopy. If that's not possible, the next best option I found is to talk with clients while you're also on a computer. So that way you can look at providers online while you're talking to ensure that you have the correct provider names. There are many practices in hospitals with similar names, or clients may just remember, a portion of the doctor's name or maybe the street name. So this is just a helpful way so you can investigate and figure it out together. And you can do it pretty quickly if you have a browser open and a Word document open and just copy paste links. You're also going to want to talk about what types of treatments they got at those facilities. Who are their primary care providers? Who are their specialists? If they were hospitalized, what was the hospitalization for? The duration. So you get more details than this as well. When you're ordering records, sometimes those are from a centralized location and sometimes they're per location of the providers. So I always like to just find out, what was the specific address location that my client went to, because you can figure out later from that provider, who do I make that request to, that specific location or that centralized location. When working with children, of course, some of this information you're going to get from that supportive adult that's working with them versus from the child directly, depending on their age and abilities. I also like to get from the beginning some releases. So releases from the client to obtain any medical records on their behalf, releases from the client to talk with any medical professionals I can anticipate. And then I have those from the beginning. Okay, so now I'm going to cover some practice tips for working with clients with disabilities. And I like to think of this as a journey. Frequently individuals who have been diagnosed with a medical or mental health condition, they may be on a journey. If the condition is new, their abilities have changed. They may be in a period of grief or loss, grieving what they used to be able to do. They might be on a journey of acceptance or of treatment and navigating their treatment plan. Or they might be coping and dealing with their condition and figuring out their strengths. So you'll meet people at different phases of their journey, and it's helpful to be aware of that and just have that understanding. Disabilities also look different in each person. So approach your clients with an open mind. Everyone is unique. You want to treat your clients with compassion and openness. Don't make assumptions. And just because you might have represented one client with a certain condition before, that does not mean they'll present in the same way if you work with a different client with that same condition. Everybody's unique and conditions express themselves in different ways and different people. Also, sometimes you might be working with a client who has a rare condition or maybe a condition that's been difficult to diagnose. So they might know that something's going on with them, but they don't have all of the answers yet. Or they may have been met with doubt, disbelief in the past, and as a result have some frustration or resentment or distrust of others. Sometimes they figured out what's going on, or they could still be looking for answers. I do think sometimes in these situations, people might not feel heard or believed, and so they stop looking for answers. And I think it's important to express trust in our clients and that they know their body and to validate them and what they're going through and encourage them to continue to seek those answers and treatment if that's what they want. I've definitely heard many stories where they just went to a different doctor or just had more time or one more test, and then they got the answers that they needed. I think that information is power, and sometimes it just needs that further time or exploration to figure it out. Of course, as we've said a couple of times, diagnoses are important. So if in this situation they don't have a formal diagnosis yet, it may not make a direct impact on their legal claim because many times that is needed to be able to access certain benefits and services or to have enough support for something. It's still helpful to have this in context though, so you can talk with your client and encourage them. If a condition is something that needs to be discussed in declaration or in testimony or in an interview, I just have a few thoughts on that because it can be really difficult for people to talk about their health conditions. You're asking your client to be very vulnerable to share personal information, and that's challenging. Sometimes people have a tendency to minimize or exaggerate their symptoms when discussing their condition. And so I think, it's better to just stick to the facts. That's usually more persuasive to adjudicators. And I usually try to get ahead of this issue by just acknowledging, this is common. And so before we get into example questions, and then as we go through example questions, if I see that they are minimizing or exaggerating just based off of the information I know, then we can have a conversation about that. Also, sometimes clients just have a hard time discussing their symptoms. They don't really pay enough attention to know or and to answer the questions that you're asking, or they just can't put it into words. And so what I have suggested and found helpful is for clients to perhaps journal in advance over a period of time and really pay attention to how they're feeling. And you can go over example questions and information that you need so they know what to journal about. And then we can feel more confident, everybody, that that declaration or that testimony is going to be more accurate because it's based off of their reflection and what they experienced and what they observed, and they can give examples. And, lastly, but maybe most importantly on this slide is just remember that our clients are people first, and they need to know that they're important, they have value, communicate to them. And you can communicate their value and worth directly. You can also communicate that by giving your time and your attention. So just listen well, see your clients, spend time with them, create space for these really important conversations, and trust them. Even if they give you information that they think would be guide their legal strategy, something that's usually for the attorney to do, listen. It's their case, it's their story. See if it makes sense to incorporate into that legal plan and strategy and express validation. I do think that in legal sphere, social services sphere, we have the opportunity to be with individuals in one of their toughest times. They're trusting you, they're relying on you. And I think our goal is to do our job in a way that's respectful and represents them well. And I know too, this can be really tough because you may be working with a big caseload, and I know that I always did. So it can be tough because there's a lot to do, there are time constraints, but I think this is really important. You don't want people to feel like a number, and you likely care because that's why you're in this line of work, and stay connected to that. Express that to clients, show them why you're involved and why you care. They're already dealing with really big systems, bureaucracy, machines, just going through the legal process, and then also the medical system and the medical process acts the same way many times. So you want to be efficient, but efficiency isn't always kind. So just make sure you're balancing the needs of your clients and what you need to do. So getting into more important considerations, just setting the context. Legal proceedings are intimidating for everyone, and those with a disability, this may be even more challenging. So it's really helpful to discuss the purpose of proceedings and their goals. Really to prepare clients well for what to expect can be very helpful and can reduce anxiety and make your client feel more at ease and prepared and ready. There might be additional needs to consider as well. So I like to go into what to expect in great detail. You also want to think about parking, security, the time that a meeting or hearing will take, so they can adequately plan for and consider any needs. This might be nutrition needs, medication, bathroom breaks. There's often a lot more involved just in relation to getting somewhere. So think through these things. You also want to think about time, because many times immigration cases last for a long time, over many years, and many conditions also change over time. So it's important to check in and see how people are doing over time. Also, someone may be diagnosed later. Maybe it wasn't an issue at the beginning of your representation, but it becomes an issue. So just keep this in mind and reassess needs along the way. To touch on confidentiality concerns, it's always best to communicate with your client one-on-one. And so you want to really try to consider ways you can facilitate confidential communication. If that's not possible for some reason, you want to try to ensure that your client is comfortable with whomever's assisting with that communication. Okay, so I did talk with someone at the Young Center just to get their perspective, and I thought they shared some helpful information when working with, and so I wanted to provide that, especially when working with detained youth. So if youth are in custody for a long while, and then maybe they're referred for an evaluation, and you get that information, it's just important to look at those diagnoses with a critical eye. So sometimes you might see a condition like adjustment disorder, oppositional defiant disorder, and it's possible that they don't have an underlying condition, but these behavioral expressions are just related to being in detention for a long time, and that's what's going on. So you might just want to look at it closer. What language was used? What was the timing? Should evaluations be reassessed after a certain amount of time? And then also consider referring for an outside evaluation, somebody that you trust for that evaluation. Also, just remember that ORR has an obligation to meet youth needs, and if they're not giving them the support they need, then consider advocating for that. Whether the child should be referred for an evaluation or an individual education program in schools, which is called an IEP for short. Also, just keep in mind on the flip side, if the child has needs, this may delay reunification. The family will then need X amount of resources to support the child, and not all children need to be evaluated. So this is just to consider on a case-by-case basis to determine if they would benefit from that additional support, and if so, advocate for them and ask questions. Of course, you also want to remember to talk with the client and the child first, just to see, are they on board with getting that evaluation? What do they think about this? Because sometimes someone might have resistance to treatment or getting evaluation, so you want to make sure to have those conversations first. I also would suggest watching the CILA-NYLA March 2024 webinar. We have some important information shared there on the Lucas R. VSR litigation, so the link's on the slide, but it has a lot of critical information. It's really helpful. So now we'll go over some tips and information regarding working with clients during meetings. So when working with a client, and I mean any client, but particularly one with a disability, it's going to be important to be prepared. And so that helps you to be very present during the meeting. Have an agenda, make sure you know your goals, and keep it simple if you can. Think in advance, how can I communicate this information well to this particular client? You may need to distill down complex topics into simpler language. You might need to break it down, go slowly. You might want to create or prepare visuals to explain issues, to present the information in different formats, considering different learning styles. You want to check in for understanding, ask your client to repeat back information, offer to repeat information, give space for questions. So these are just a few tips and ideas. It's going to depend on the client. And a lot of this, I think, is just being very intentional and being prepared, thinking about this in advance, not on the fly. You also want to think about your environment, your physical space. If your client has mobility challenges or balance issues, are the pathways clear, wide enough? Is there even ground from the parking lot to your office? How many stairs are there? Is there elevator access? So there's going to be unique needs and aspects to consider for each client. And then just during the meeting, be a good listener. Don't make assumptions, stay calm, smile, do what you can to help the client feel welcome and comfortable. You're going to need probably extra patience and willingness to be flexible. Some things take longer, and that's okay. So just to give a few examples, one, you might be working with someone who's dealing with chronic pain or has distracted thoughts. You may need to have extra patience and grace. And if they're curt or say something that's a little bit rude, it may be because what they're dealing with and not have anything to do. So try not to take things personally. There might be times when you need to schedule a follow-up meeting to finish, or you might need to, make the meeting that you're at last a little bit longer. So just make sure there's a buffer in your calendar to do that. Another example would be maybe you're working with a client and you're not aware of any disabilities, but they casually mentioned they're struggling in school. And you've noticed that they presented as younger than their age. They seem to be processing information very slowly when talking, and you're not sure if something's going on. So one approach could be to order those school records to see if you can get some more insight. Maybe you get another opinion from a colleague to see if they noticed anything, any difficulty with understanding, communication, comprehension. So you want to be proactive, but not jump to conclusions. You might want to explore that situation first a little bit more before suggesting or asking about testing. I also think it's helpful after a meeting, think about what your client needed for that meeting to go well. Sometimes people can tell you what they need, and I do think it's important to ask for that. I also found that you may figure it out by just observing them and being a good listener. So this may relate to the pace of the meeting. Try to tune into that and match their pace, the level of language, the simplicity that's needed, their mobility, whether they seem stressed or easily got emotional. So I tend to take notes of that after the meeting. That way, the next time we meet, I'm going to be better prepared. I'm going to do an even better job to try to work with them well, and it also helps anybody else in the office who might have conversations with them too. So it's also helpful to just learn how to recognize signs of distress or decompensation during meetings or hearings, and on this you want to be proactive. So consider planning for managing stress and anxiety, and try to identify triggers, identify coping mechanisms, and discuss a plan before something like court or interview appearance so that if something happens, you're ready. You might also want to collaborate with mental health professionals if they have a provider, or if not, if your office has a social work team, collaborate with them. Provide access to support services immediately if needed. And we have a CILA resource on navigating difficult, challenging situations, which goes through various scenarios, provides example scripts, so it gives a lot more detail than I'm able to give right now, that I would suggest looking at that resource. I've also linked on the slide our mental health and behavioral toolkit because it goes through a lot of different conditions. So if you're not familiar with a lot of mental health conditions, for example, this would be a great resource to look at to become, just as a starting point, to become familiar with those so you can identify issues. I'll give another example here. Maybe something challenging occurs or client experiences distress and maybe they get upset or even start to yell. It's important to know that you can do everything you can do and things don't always work out, or someone may get upset. Many times there's a good reason for it, and it's not always about you. It's something going on in their lives or something else there's no control over. Other times there may be something that you can do to try to help. You can try to address the need that they're expressing. But either way, you can be present in that moment and try to offer support, to listen, to validate, to give time, breaks, transition to what you're wanting to talk about, or maybe just reschedule. I will say sometimes clients do go too far in terms of how they treat or talk to you. And so identify when you can listen and take it and when you need to put a boundary down. So this is a judgment call. It depends on the situation, but sometimes you may need to assert a boundary. You can't speak it to me in that way. Give them notice that you'll hang up the phone or end the meeting if they don't change their tone. And this might be after you've done your best to validate and de-escalate. In these situations, it may be helpful or necessary to get backup from someone you work with as well. And if you are a supervisor, it can be helpful to talk about these types of situations in advance and to let those you work with know that if they ever need help asserting that boundary or just need backup, that you're available. You might work sometimes with a client who is volatile or has erratic behavior, and sometimes that's related to their condition and sometimes it's not. So be ready and prepared for those situations when you can. Now, just talking about boundaries, sometimes it's not about how you're being treated, but instead maybe just a client is asking more of you than really you can or should give. And so you might be limited in the support you can offer, and here you need to put a boundary down just on what support you can give, what you can't give, set expectations. What's your role and what is not your role? So you can do your best to give resources and referrals to fill those gaps to provide the support in certain situations, but that's another place where boundaries are oftentimes appropriate or necessary. Okay, so in general, it's important to remember self-care when you're doing this work, but I do think it can be easy to get so wrapped up in a case or trying to help a client, and you kind of forget yourself in the process or don't prioritize your own needs. And sometimes advocates may struggle when working on a case such as this because it's hard, it's tricky. It can be emotionally draining and there's a clear need and you want to do everything you can to help. Sometimes these challenging conversations come up more often, or they may be more intense in these situations too. So I just want to spend a moment to reiterate that you matter and care for you is important. So sometimes after an experience, it helps to reflect on what happened. It may help to journal or write down your feelings that were raised during dealing with the situation. You might just need to take a break. For myself, I can talk from my own experience. Sometimes I like to take notes directly after a meeting just to get all the information out that I needed to document, for my organizational purposes or for my own purposes. And then I'd like to take a walk to clear my head so I can on to my next task. For me, that movement, being in nature, getting some fresh air, it's restorative. But if I didn't have time for a walk, maybe I would do some light stretches or smell aromatherapy oils just to give myself some calm. This is different for everyone. So I'm just giving a couple ideas that help me midday in my experience. But think about, is there something that you can do to help you yourself to recenter, to have some balance? Can you reach out to a colleague or a friend for support? Again, I'm just touching the surface on this topic, but I thought it was important to raise in this context. We could have a whole training on self-care, and we have had training on self-care, and others have, of course, too. So I put just a couple links in the slide if you would like to explore this more. So we talked a lot about records and medical providers. I did want to just flag here, give some tips when talking with medical providers. Know that when medical providers hear the words lawyer or legal system, many first think medical malpractice, litigation, risk. It's not a good first thought. So it's important to think about what's the common thread here, your client, their patient. That's who they have a duty to, likely want to keep happy, want to keep their business, want to do right by them. You might also be thinking about my goals and their goals. And I think it's just important to recognize that sometimes those goals are not in alignment. Sometimes they're not the same. Sometimes they're just vastly different. That may not be the right approach. Instead, focus on the client, the patient. The goal is them to help them. So I would usually like to talk to my client about what is needed from that doctor and medical provider and empower them to ask for a statement. The client can say, this is important to me, something I need, appeal to them and ask for help. And they can also express and communicate the importance of having that statement from that treating physician or that counselor, someone who knows them well is giving them treatment. I would usually give my client a questionnaire, a form, a letter explaining the information that we need, and then the client can hand deliver that to their provider and try to get it back, signed, completed. I'd also give my client my business card. That way, if the provider wanted to ask me anything, talk to me, I'm available, of course. So sometimes providers would call me directly because they'd like to have more information. Sometimes clients would come back and say, I don't think they understood, or can you just help, do this. Sometimes I get the form back and I was reading it and it's internally inconsistent or it's missing really key information. So I'd want to contact that provider to get clarification. So there are definitely many times when I was working with the medical providers directly, it's just not where I started. My advice also is, if you're getting a letter from a medical provider, recommend that they use plain language when explaining the condition and any impacts or needs of the client. Judges usually aren't doctors either. So giving them something that has overly technical language is not going to be very persuasive or helpful. As an advocate, I also want you to feel empowered to talk with medical providers. And sometimes I have heard from people, this is intimidating. I don't want to talk with medical professionals either. And so just as a reminder, they're just people too. You know your job, they know their job. Just make a game plan in advance. What do you want to communicate? What do you need? If you think they're going to have certain hesitations or problems with it, how will you address those things? Because sometimes you are aware, they're not really that interested in helping out. So if you know those things going in, how are you going to address it? Make a strategy before making that phone call. So now I'm going to pass it to my colleague, Marissa.
Thank you, Laura. As we mentioned before, many times you're gonna need additional support in these cases. You don't have to do it alone. You may need to talk with family members who are brought. You may need to get records, as we mentioned earlier, to organizations that can be possibly help with this include, like, for example, Justice Emotions and Keep Families Together. We included links to their organizations and websites and link in this PowerPoint, which you'll be getting, and also some CILA resources. Keep those organizations in mind and options as you navigate these challenges with your clients. Additionally, if you're working with a client with a disability, you should consider whether you should refer a child for an appointment with a child advocate with a young center. You can find the referral form online, and it's linked to the slide as well. They describe situations where it's appropriate to refer a child, and there may be factors that are potentially relevant here. For example, a young child from under 12 years old, if an accompanied child has a physical or mental disability, child is considered to be exceptionally vulnerable. We also link to relevant EOR Director's Memorandum policy guidance by EOR that relates to child advocates that are important to consider if the child is in removal proceedings as well. Okay. And now to a little interaction. We want to hear from all of you. We have mentioned, this work is difficult, and doing it alone is even more. So as a community, we can work to navigate these challenges, making the work more sustainable. So I want to invite all of you to explore this hypothetical scenario with all of us. Share us your tips, guidance, considerations for navigating such scenario. Maybe you already have experienced this challenge before, or maybe you're currently working through it. So the hypothetical we have here for you is, you're working with a client to prepare their declaration. Your client begins crying and is very emotional. She tells you she continues to have hypervigilance and nightmares based on what she has experienced. It's difficult to continue writing the declaration. You take several breaks and ask your client if they would like to keep talking about this now, or they'll like to schedule another meeting. They like to continue. You're not sure whether they have sought counseling or not. So what do? If you don't mind, scan the QR code on the slide, or you could go to slido.com and insert the number there and tell us, how would you navigate this situation, or how have you navigated this situation before? See, a lot of people trying to type, so we'll give it a minute. Take breaks and ask how they're feeling. Yes. Give it a moment. Summarize, paraphrase, listen, and then ask how you can help. Yes, for sure. Open-ended questions are very important. Centering the client. Now they're coming too fast and I can't read that fast. Ask them if they would like to try grounding techniques. Yes, ask the client if she would like to. Don't worry if you're missing all of this. We're going to make sure that we download all the questions. We're going to compile them and share them with all of you. They are coming super fast that I can't read, but as I could see, very helpful tips, which we're gonna, like, again, we're gonna compile them and share with all of you. Is together we're stronger. We learn so much from each other, and support is so important in this work. I'll let everyone, I see more people trying to type, so I'll let those that come in so we could have it. But I promise you'll get it, and we'll, some of the pointers that we would give, it's important to, as some of you mentioned, use open-ended questions to allow them to share at their own pace, acknowledge the difficulty of them sharing, to reassure them that that it's okay, and do not make any assumptions, of course, about their current support system. Gently suggest maybe possibly seeking professional counseling if they haven't already. Emphasize that it's common and helpful for people who have gone through similar experience to seek counseling, and that's their strength in seeking help. Offer to provide a referral if they are willing to. Even if they're not willing at that moment, that's okay. You could provide them that information, and it's up to them when they want to follow. Give them that agency to do that. It's also important to be supportive, to remember, to set those professional boundaries. You're there to assist with specific tasks, not as a counselor. I know that, of course, provide support, encourage empathy. But as Laura mentioned, we're not there to diagnose, but if you suspect that there's something going on, of course, provide them the information, support them, and open that. Yes. So much great tips. Whatever I was able to read, it's amazing. Thank you so much for sharing. Sorry this came super fast, but I promise you'll get this information. And now I'm gonna pass it back to Laura.
Thank you, Marissa. Okay, so now we're going to talk more about responding appropriately in legal settings. So we're going to give some just general tips, practice tips for various legal settings. First, I think just familiarize yourself with any applicable rules given your setting, UIR, USCIS, state court. It helps to know what to expect at a baseline so you can assess the situation better. And if you haven't gone to this particular office yet or this immigration court yet, ask your colleagues with that experience, and maybe go on another occasion to scope things out, to observe and ask any questions to get prepared. So do your research. There's other ways to do research as well, but those are a few ideas. You also want to build relationships with court personnel and interpreters, security guards, judges, clerks, just having good rapport with them. That helps, because if something happens and you need help or you have questions in a pinch, then it's just going to be easier to do that. Of course, you always want to communicate openly with your client about their preferences and their needs, and get the records and have conversations about their medical conditions and the impacts, and asking about what they need. So just having those conversations are important. I'm going to give you a couple examples here. So one example is you might be working with a client with a seizure disorder, or maybe a gastrointestinal condition, so a tummy condition, or maybe they have anxiety. And it's possible that their condition worsens with stress. I think that's a pretty common trigger for a lot of health conditions. And so, well, guess what? You're planning to go to court or that asylum interview. That's stressful, right? That's stressful for anybody. So make a plan knowing that their symptoms may worsen that day. Be ready for that potential situation. Another example, your client may be taking a medication that makes them drowsy. So this might make it harder for them to communicate at times or to think clearly. So I might be having ask my client questions or having conversations about, when were they going to take that medication? What's the timing for it? How long does that side effect typically last, or when does it kick in? To try to assess, is this going to happen while we're at court or we're at that interview? You also may need to ask them to consult with their medical provider. Sometimes there's flexibility when you can take medications and they could just change that timing. That is something you have to definitely defer to a medical provider on. So there might have that possibility, or you might want to just have a letter or documentation regarding that condition, their medication, and that side effect. That way you've created a record, and hopefully the adjudicator will have more understanding. But you can also foresee a scenario where this happens and you didn't create that record, and it can become a real problem. when the adjudicator is assessing their claim. So it's really important to think about these things. I'd also suggest consulting with others in advance. So this may be your supervisor, a colleague with helpful experience, the medical providers to get records or evaluations or statements that you need. This can inform what accommodations you're asking for, and so you have support to do so. If you plan to seek accommodations, make a plan for that and seek those in advance. And it's best to have it in writing. That creates a record, and it also gives everybody advance notice. You might have noticed this as a general theme in my comments, but just be prepared, have a plan, and be flexible, because things happen and you may have to adapt in the moment. You're making a lot of micro judgment calls in these settings. Things don't always go to plan or perfectly. This is not our focus, but we did have a couple slides related to USCIS and EOIR. So we just want to point you to some information on these topics for further review. In general, federal law prohibits discrimination based on a disability in immigration proceedings, and it requires that the government provide reasonable accommodations to enable immigrants an equal opportunity to fully participate in and enjoy the benefits of the proceedings. So the USCIS website has information on disability accommodations for the public, and it's really helpful because it provides example accommodations and provides more specific common scenarios. There's also an online form on the USCIS website where you can seek accommodations, and will provide some other instructions as well. There's also references in the USCIS policy manual and some asylum guidelines, like the affirmative asylum procedures manual and the asylum officer training modules. So those links are in the slide so you can further. I couldn't find a link to an EOIR policy regarding disability accommodations like I did for USCIS. And based on a Human Rights First report that's linked in our handout, I don't think that exists. So the top link here is to EOIR's website with court information, because you may want to check out your local court in advance or contact them to find out information particular to whatever your client needs. I also linked to some key director's memoranda, agency policy that you can look to for guidance. So these do not focus on individuals with disability, but you can use many of them and different aspects of them when determining your case strategy and deciding what you're going to advocate for related to just issues involved with children's cases or language access, including communication disabilities. We also think it's important to be aware of and read the BIA case matter of MAM. So there are whole trainings on this topic, as Marissa says, we're not diving in, but I'm just flagging this issue and noting that the government must provide safeguards to protect an individual's rights and privileges where they're not competent to participate in the immigration court proceeding. So this may most frequently come up if your client has a cognitive disability or as a result of a mental health condition. And matter of MAM lays out a framework for assessing competency and providing safeguards. A motion for safeguards may still be appropriate, though, even if your client is deemed competent. I'll also note that CILA just last week issued a blog post on this topic on a matter of MAM, a competency hearing. So that's linked to in the slide, and we have more resources in the handout as well. I'll also note that even if your client is, maybe they are competent, but they have a disability and it impacts them in different ways, they may benefit from a reasonable accommodation based off the Rehabilitation Act to provide that meaningful access to programs and services. So then it may work best to file a motion for reasonable accommodation to the court in advance of the hearing. And you'd likely want to attach supportive evidence that's relevant to explain the disability or support the diagnosis, the medical evaluations and letters. So it's just going to depend. We are now going to turn to another hypothetical. Lido. Okay, so here you're working with a 17-year-old client who has a respiratory condition. The case is prepared and you and your client are prepared. On the day of a hearing, you meet with your client early as planned. You go into a small meeting room and it's immediately evident to you that they're having exacerbation of their symptoms. They're having a labored breathing. They can talk to you, but they have shortness of breath and wheezing and must talk slowly. What do you do? So we'll give a little bit of time here to put your answers in. Call 911, one response. throughout the meeting, get help. Seek help during the hearing. Ask them if they have medication available. You're going to want to assess the situation, right? How severe is this? Remove ourselves from the small room to a more open space. If like threatening, call 911. Let them know we can end the meeting whenever we want. We can reschedule, give them something to color to kind of give a distraction, I think, there. Get help, let the court know, get a reset, extremely cautious, monitor symptoms. Next time, consider accommodations, maybe a different room, if maybe there was something in the environment triggering that. Slow down, get help. Contact their caregiver if they give consent, inform them of the situation. Request medical assistance, get medication if needed. Learn if there's particular accommodation needed. Ask the client if 911 needs to be called. So there's a lot of good answers here and a lot of considerations, right? It's going to really depend on what's going on in that moment. It assess the situation. Something like an inhaler would immediately help be able to proceed shortly. Get medication and we'll request medical assistance. Get help, let the court know. Let them know not to worry about the hearing, we'll take care of that. So there's a lot of answers coming in. I will say I'm loving the answers here. You know, I think these are perfect and really good considerations to have. You know, ask how to assist them. So I will give my experience with a similar situation I had. I will note this came up when I was practicing disability law, and I was working with an adult in this matter. So there's a couple of key differences. But just you know, I had a very similar situation happen. And with disability, it's basically a merits hearing. So that's what we're ready for. But this can be very nerve-wracking, right? You know, it's stressful to be around someone who can't breathe well. I think it's important to remember to stay calm. And in that situation, I told the client, you know, we can continue this hearing. We don't have to go forward. They're not feeling well. In this situation, my client wanted to move forward. You know, that was important to them. They thought they were capable of doing that. I knew the judge and I thought they were very reasonable. So I took my client's lead and we moved forward with the case. It wasn't as dire as the situation that we needed to call 911. It wasn't at that emergency level. You know, but I did change how I would typically do things. So frequently when meeting beforehand, I might talk with my client. We might go over a few direct examination questions to get them warmed up to have a strong start, go over some reminders. But you know, here we didn't do that. We were prepared. We weren't reliant on this time to get prepared. We just sat together in the quiet, you know, trying to let my client rest. They didn't need to talk. And then when we got to the hearing, I changed what I planned to do for that hearing. You know, I planned to ask them certain questions. We didn't do that. Instead, I changed the order. I changed my questions, and we started with, you know, what's going on today, so they could explain to the judge, and the judge could really see how they were doing. This was a disability claim. It was working with an adult, likely different in this context than an immigration claim, but some of the same themes do remain the same. You know, stay calm, even if stressful, difficult situations come up. Consider, what does your client want to do? Ask them, you know, what help do they need? It's helpful if you know the forum, the judge, factors that should be considered when making these decisions. Be ready in advance so you don't need that extra time to prepare. Be willing to just sit with your client or help them if they need more help, support, assistance. In this situation, my client didn't need that much from me, but there might be a situation like y'all pointed out where they really do more intervention and more help. And be flexible in your approach. You know, what you were planning to do that day, that didn't happen. Also know yourself. You know, how do you usually respond or react in an emergency setting or when a medical situation comes up? Do you kind of panic, or are you able to really stay calm in that? But you might want to think about bringing a partner or colleague in really difficult cases. I could see that being very helpful in a situation where you do not want to leave a client alone, but there might be a point you need to go communicate something to an adjudicator. So anyways, you brought up a lot of great points, but I just wanted to share a little bit from my experience as well. Thank you so much for that. Okay, so we've been talking a lot about advocating with empathy, awareness, and practical guidance. And we've been focused on what an advocate, an individual can do, and issues to think about. I think it's also important to think about what can we do as a collective, as an organization, for example. So it's helpful for organizations at large, for staff and leadership to think through some of these issues collectively on a larger scale and work together. So I'm not really making a suggestion for a particular method here, but these cases do bring up complex situations. So I'm just going to pose some questions and issues to consider and maybe ask that you think about. So does your intake cover disabilities or health issues? At what point is this discussed? How can you or your organization be proactive about these issues rather than reactive? As an organization, do you have guidance, plans, resources, trainings on working with clients with disabilities? Have you thought through challenges people face with accessing the legal system and their claim, and how we can make the process more accessible, accepting, encouraging, and more supportive and understanding? Establish relationships locally. Trusted providers to make those referrals for evaluations. Locally doing research, places that provide services to immigrant populations for medical and for counseling, or perhaps have more flexible payment plans or provide free services. Do you have relationships with others locally with specialized knowledge that you could consult with on a case or get guidance? Because sometimes that consultant piece is really helpful. Do you have internal trainings based off collective knowledge and available resources? And I'll note we did a collective internal CILA survey so I could learn from others on the team what their experience was on these cases, which I thought was super helpful. Being intentional and taking time to think through these issues. And are we just supporting each other as colleagues? You know, this is difficult work and challenges come up. So thank you so much. And now I'll turn it over to Marissa.
Thank you, Laura. As advocates, we want to encourage autonomy and self-advocacy. The goal is for the youth to tap into their own internal resources, their strengths. This will empower them to take ownership of their experiences and advocate for their rights. When they or anyone feels empowered, they speak up, they advocate for needs and make choices that align with their needs and values. They develop a sense of agency and self-confidence. For example, you as the advocate are working with a youth and you're helping them navigate the IEP meeting. Rather than speaking on behalf of them, you could advocate by role playing, maybe practice with them on how to speak their preferences, their goals, and advocate for the accommodation and support services they need. Or maybe they're looking into getting a job, instead of filling out the application for them, work alongside with them, show them the process, give them tips, and you could role play with them as well. There's so many things that we could do to help them out, feel that sense of agency and autonomy for sure. So as we wrap up this webinar, let's take a moment to, first, some last reminders here. As we wrapped up, don't forget to fill out the feedback survey. The PowerPoints and handouts have been uploaded to the webpage dedicated for this webinar. The link has been provided. I'm going to email it just in case you did not get it. The recording is also going to be uploaded to the website at a later time once we we're able to work on it. Stay connected with CILA, join our newsletter. If you need technical assistance, don't hesitate to follow up with us. And yeah, we're so happy to have you here. Follow us on social media. We are in Facebook, YouTube, X, and LinkedIn. Yeah. And final thoughts, as we wrap this webinar, let's take a moment to reflect on the insights and strategies shared over the last hour and a half by Laura, Shalom, and myself. As the journey lies ahead, we hope you found something that resonated with you or proved helpful in your advocacy endeavors. As you move forward, we encourage you to carry these lessons with you and extend the conversation beyond this virtual space within your organization and communities. It's through ongoing dialogue, learning, and actions that we can collectively drive positive change. Before we conclude, let's also remember to be kind to ourselves. We're bound to face challenges and make mistakes along the way. It's one of my favorite poets, Maya Angelou, said, do best when you can. Do best you can until you know better. Then when you know better, do better. Every interaction and effort presents an opportunity for growth and progress. By approaching our work with compassion, empathy, and understanding for others and ourselves, we cultivate an environment conducive to positive change. Thank you for joining us today and for your ongoing commitment to making a difference.